for the day.
Yeah, I took some notes.
And the moderator told me I should not take any time to introduce my good friend, long-term colleague, professor of law.
Okay, thank you, Gary, for that great introduction.
So I'm not going to introduce my good friend, longtime colleague,
Thank you, Gary.
Professor.
Thank you,
Take
Gary.
it away, Eric.
Thank you, Gary. Thank you for all of you still being here. As you might know from reading the announcement, our panel is about targeting information, and I'll talk a little bit about that in just a minute. But first, I'm going to briefly introduce our panelists. I'm doing these in alphabetical order because that's how I wrote it down. So first we have Tsvetelina on the far end. She was the chief editor of the Oxford Transitional Justice Research Group back in 2018 and 2019, and has since been the head noter for the European Human Rights Report. She interned at the policy branch of the United Nations Office for the Coordination of Humanitarian Affairs. She's currently at the Oxford Institute for Ethics, Law, and Armed Conflict. Emily, sitting right next to me, is obviously a major in the United States Army, if you didn't notice. She's currently a faculty member at the National Security Law Division of the Army's JAG School, but she is on her way to West Point this next summer, and there will be part of the law faculty and also part of the Lieber Institute, who is co-sponsoring this program. Gavin Korn, if you don't know this, there are 5 Korns. Did you all know this? 5 Korn brothers. Just as a side note, we have made a commitment in the car this morning that there's going to eventually be a 5 Korn brother podcast called Cornucopia, where all 5 of them will be on a podcast arguing amongst themselves. I cannot wait for that. And popcorn.
That's
So
my dad.
But this is your introduction to one of the Korns, Gavin, who started out his career in the criminal division at the U.S. Department of Justice. Upon leaving the government, he went to work for Facebook and is now working for Netflix. And then Ori, from 2015 to 2021 was an assistant legal advisor for cyber affairs in the International Law Department of the Israeli Defense Forces. He is now a faculty member at the University of Cambridge. So he works at the University of Cambridge. You tell us how you would describe yourself, Ori. PhD candidate. So we are all here to talk to you about targeting information. And we're going to run this panel a little bit different than the other panels have run. We are not going to save our questions to the end. So we hope to engage with you in a conversation. I have 4 experts up here and we will come back to them often, but I hope that you will engage with us in this discussion as we go. We are going to do this in kind of 2 blocks. The first one will be talking about information more generally. What is information? How do we consider things to be information? How does data fit into that? And more of a defensive, how do we protect information? What types of information should be protected, et cetera. Then toward the end, we will transition to maybe a more offensive nature, where we're going to think about, well, in what situations can we target information? How should we target information? What are the impacts of targeting information? So that's how we're going to proceed. So let's start with the idea of what is information. Now, Emily has just been, she's written an article with Sean Watts, it's just been accepted by the National Review of the Red Cross, so it's not out yet. But in this article, they deal with the concept of information. So Emily, why don't you start us off by just talking about information? You can.
Thank you. And thank you so much for asking me to be on this panel. I was just a participant last year and so honored to be here. I am new to the academic club. So thank you all for being such warm welcomed people who welcome me to this. I truly believe it's a club. So I first want to start a little bit with where I'm coming from. You know, Gary talked about the operationalization of a lot of what we've been talking about. I hope to bring a little bit of the operational perspective to today's panel. And part of that's talking about what I do currently and why that will be relevant later. So for those of you who don't know, I just briefly want to talk about what is the Army JAG School, who are our students, and what is our general mission. So the Army JAG School is located in Charlottesville, Virginia. We're right next to UVA Law. It's a beautiful place. If you have never been, please come visit us. And we have a wide range of students, right? I teach JAGs. Our flagship course, we award an LLM So we are the only ABA accredited DoD school that awards an LLM. So those are my peers, usually mid-grade majors who come to get their LLM. I teach basic course students, so brand new Army lawyers who have never worn a uniform or have only worn a uniform for just a few weeks. But we also teach commanders. And in many ways, I think those are our most important students. So all senior commanders, 06s, brigade commanders, and now we've expanded it to battalion commanders, have to come through our school for a 1-week course, for a crash course on legal education. And from our department, that means talking to them about the law of armed conflict, or IHL. We talk to them about intelligence oversight, because data has become such a prolific issue when we talk about the protection of civil liberties here in the United States, war crimes and command responsibility. And then I also teach general officers, so brand new general officers who come through and they always want to learn about cyber, right? Because it's the new hotness. So I say that to say, when I teach the commander specifically, you know, in the first panel, the question was, what keeps you up at night? For me, the answer to that is very easy. It's my 2.5-year-old twins who won't stay in their bed at night. But separate from that, I do worry a little bit when we talk about these concepts of how international law applies to cyber. How can I teach commanders who will be forced to make these decisions, right? They are making the targeting decisions. How can I teach them to make well-guided legal decisions in the absence of a legal advisor? Whether because that legal advisor is not geographically located with them because we are in a more dispersed posture, or to be perfectly frank, because that legal advisor is dead in a large-scale combat operation scenario. So all that's to say, that kind of just gives you a framework of where I'm coming from and how this has been so helpful to me as I bring this information all back to the school. So to your actual question, Professor Jensen. So information, the Army, and it was alluded to in the general's talk when she first spoke, the keynote speaker, about the Army recently came out with the Army Publishing Directorate 3 TAC 13. It's literally called information. And it has a definition of information. And the definition is data in the context to which the receiver processes and assigns meaning, and receivers can either be human or automated systems. So of course, humans, we assign meaning to data, and we process it based on our education, understandings of the world, things of that nature, and automated systems, of course, through programming and what they're designed to do. And so what's really interesting, and again, I can only speak from the Army's perspective, which, by the way, everything I say today is coming from my personal perspectives and don't necessarily reflect the decisions or perspectives of the DoD or the Army. But the Army has gotten away from a term called information operations, which takes a more aggressive sort of posture towards information, use of information in combat scenarios, because it was focused on combat scenarios. And we've taken this idea of information advantage, which the idea is to span the entire conflict continuum from competition to large-scale combat operations. And so when we talk about data, when data is processed, it becomes information, then it's analyzed, it becomes knowledge. And then when we apply our judgment, that influences how we understand that specific data. So from that perspective, that is what we, in the Army and the Army's understanding of information and how we plan to in the future and currently use information to sort of shape the United States position from a competition perspective, and then if it comes to it in actual combat. And we do this through what we call information advantage informational activities. So that's enable, protect, inform, influence. And the word attack is used, but it's used specifically in the context of combat operations, and that attack is used to disrupt the command and control of an adversary. So there's a very narrow sort of idea or envisioning of how we use attack in the information space. And so I think I'll stop there. I hope that answered your question to a certain extent.
Definition one more time.
Of information.
Yeah.
Information is the data in context to which the receiver processes and assigns meaning.
All right, Gavin. So from a corporate America standpoint, is that your definition of information? Or how do you view information?
So first, let me start by thank you for having me here. I'm going to say that I appreciate being invited to speak today. And I just want to make clear, I am not speaking here today on behalf of Netflix, in part because Netflix really doesn't, they don't really have, it's not a social platform. They don't have the same sort of content or information that I've seen in other companies. And my experience is basically from working at Facebook, where I was in charge of the global law enforcement outreach team and also the cybersecurity law and investigations team, and also in the US government before that. So I would say my definition is very much influenced by my time in the government. And in my role as the counsel to some of the teams that respond to requests from data or demands from data that come from the US and other governments. So it's kind of broken down in my mind into content and non-content that kind of maps to ECPA, and also communications and non-communication. ECPA being the Electronic Communications Privacy Act, which is under US law, the statute that controls basically when the US government or other individuals can get access to data that is possessed by a provider of electronic communication services or remote computing services. Those are, essentially, if you're providing a platform where people communicate with each other, the public can use it. You're an electronic communication service. And that statute divides these things in that way because it requires a search warrant for some sorts of data for content. It requires a subpoena or court order for other types of data, like metadata related to communications or data related to an individual to whom the other data might relate. So an account holder's name, email address, IP addresses, things like that. So that pretty much for me covers the gamut of what is the sort of information that would be sought under certain circumstances by a government agency in order to support an investigation or to, for other purposes, for cybersecurity, defensive purposes, et cetera.
Okay, so we could think of information in the very narrow, am I still on? Doesn't matter. We could think of information in the very narrow sense with respect to targeting information, but we could also think of information in the very broad sense of basically all data or information that is out there, right? Or in Tsvetelina, what would you add with respect to the definition of information for us?
I very much agree that there is a question of content itself, but also the communicative function of information. And part of the way in which I've thought of this relates to how we think of information operations under international law and the protections that we can think of information in that context. And in a paper from 2 years ago with Duncan Collis and Talita Diaz, who appeared a little bit earlier on the screen, we thought of these information operations as the deployment of certain digital resources to create a cognitive effect in a targeted audience to reinforce or change certain attitudes and behaviors. And now when we think of this in this kind of broader sense of information, which is what are we trying to actually achieve, which is some kind of alignment with the interests of the person or persons or entities who are deploying this information operation, we start seeing that this definition doesn't tell us anything really about legality or illegality, but is more a factual question of description, which we can then fit into different rules of international law and categorize on the basis of harm, intent, purpose, whatever other subjective elements, veracity of that information, anonymity of the author, etc. So just for this initial round of conversation, I would say that the communicative function of information is really important in the context of all the discussions we've had yesterday and today in terms of impact on the audiences.
Excellent. All right.
Yes, I don't think I really have too much to add to my co-panelists. I would certainly agree with Tsvetelina that at the end of the day, defining information in and of itself is not so much of legal consequence, at least looking at it from a legal advisor's perspective. I used to be a legal advisor. I'm not speaking on behalf of anyone, just to make that clear. But at the same time, when it comes to looking at information, what I found to perhaps be the most crucial aspect is that essentially all types of information or data essentially comes down to ones and zeros on a computer, regardless of what it serves, what its purpose is, whether it's your Microsoft Windows or your iPhone iOS or your PDF files or even log data which records what occurred on a certain computer device. It all comes down to ones and zeros in a computer, which are translated by gates in a computer system into something which might be of use to a user.
All right, so I think we can at least say that in our descriptions of information, there is a broad definition of information, and then particularly with what Gavin said, there is a narrower subset, or we can divide information into subsets, communicative, or information of some kind that you may want to gather for certain purposes, right? So we want to look now at one of those subsets of information, and this is a subset that you're all very familiar with. This is misinformation, disinformation, malinformation. And let me just give to you the definitions that the US CISA says to these. In the US CISA says misinformation is false, but created or shared with the intention of causing harm. So that's misinformation, not necessarily intended, but created or shared, or sorry, it's always false, and it's created with the intent to share, to create or cause harm. Then there's disinformation, deliberately created to mislead, harm, or manipulate a person, social group, organization, or country. So contrast that misinformation and disinformation. And then malinformation, based on fact, but used out of context to mislead, harm, or manipulate. So you don't have to agree with those three definitions, and we can argue about those definitions if you want. But thinking about that subset, either false information not intended to harm, true information misused or created to harm, or information deliberately created to cause harm, how do you figure that into the subset of information that we are thinking about in the cyber and information realm? With respect to the information that we want to protect or the information we want to communicate, how do those definitions provide meaning for you in the context of this panel? Tsvetelina, let's start with you.
Yeah, happy to. One of the distinguishing lines there in the categorization is the idea of veracity of information. And this might be relevant for certain rules, but it might not be relevant for other rules. So for example, in the 1936 Broadcasting Convention, there's a question about the prohibiting of incorrect statements. But when we think about this in the context of rules of international human rights law, it's not necessarily the case that this distinction of the veracity of information really matters. And something that I worry more about is the manipulative element of information operations. And especially because you can actually harm by providing truthful pieces of information. I think back to many of the information operations in my part of the world, in Eastern Europe, around the migrants who are coming from Syria, and how you would take bits and pieces of truthful information to create a completely manipulative narrative. So in this sense, first of all, to challenge this idea that this necessarily has a legal meaning, it will depend on the rule in question, but also that I think it's not necessarily the harm that we should care that much about, which is on that basis, but it's more about the types of harms which might not be based on falsity of information.
Right. I mean, as an example, the 2016 DNC hack was harmful, not because it generated false information, but in fact, because it publicized true information, right? Okay, Ori, anything you want to add on that?
I don't think I really have too much to add. I think, again, as Tsvetelina pointed out, at the end of the day, what we're primarily interested in is less the definitions and more what's the consequence. But then again, what rules are we trying to put onto those consequences? We discussed earlier today non-intervention. I have quite skeptical views on the scope of that rule. I don't think we would be implicating sovereignty, territory, or territorial sovereignty in that respect, and certainly not use of force. And that's why probably human rights might be the most relevant framework to look at those types of things, and very specialized regimes, which may occur under specific treaties. But at a broader level, at the end of the day, I think it's less about those definitions and more what's going on.
Okay, yeah, go ahead.
Sorry.
No,
I think what I'm hearing also is it's a perception issue, right? So it's not even necessarily what's true or untrue. Somebody mentioned the Snowden links and how that may or may not have spun, the narrative of that may have spun beyond what actually was leaked. But it didn't matter because the intelligence community had to react and reacted accordingly, and our authorities from the domestic side became tighter. So I know we're not talking about intelligence authorities here, but it's just one of those data points where we say it's not necessarily whether it's true or untrue or the harm. What is the perception that's being put out, and what is the response, either from a domestic or global standpoint? Thank you for letting me know.
No, of course.
Yeah.
So let me pause with the panel here for a minute and just open it up to you all. To what extent do you find those definitions helpful? To what extent do you find them unhelpful? I thought maybe you're gonna come kick me off the panel. Take over. Ladies and gentlemen, Gary Korn. To what extent do you find those definitions helpful, unhelpful, particularly in the legal sense of what we're trying to talk about here on this panel? Any thoughts out there? I'm going to drag you into this willingly or unwillingly. Please, sir.
So particularly for our Oxbridge friends from across the pond. So I'm seeing, kind of the distinction between the veracity versus the manipulability of information versus kind of this two-tiered almost, kind of like access to the information and then what do you do with that information afterwards? So is it Mr. Pomson?
Yeah.
If we're not so much concerned with what is being done with the information, which kind of adheres this idea of access to the information as being the most important thing from a cybersecurity standpoint to protect, what then becomes the value of the information inherently that we're protecting, right? Because it doesn't, does it not defeat, kind of like this idea of breaking down almost a hegemonic approach to information, storage?
Well, I think taking a step back, I think we've got to ask ourselves, what are the rules which actually apply from the international legal perspective? I'm only speaking here from an international legal perspective. I have very little knowledge on domestic law. And what we're primarily interested in is how various uses of information fall into existing rules, which is why I would say that we're less concerned specifically with how we define like the definitions given by US agencies and others, which may be very useful for communications within an organization, certainly very useful for communications within an organization. But as a lawyer and looking at it from a purely legal perspective, it's more of looking at what's being done and seeing, do those elements fit the same elements which the existing rules apply to? So if we take the prohibition on non-intervention, does spreading false information, does leaking DNC emails meet the elements of the prohibition of intervention? In other words, a prohibited intervention, whatever that may mean, in the internal external affairs of another state. And then we'll come up with an answer.
Yeah, a small point on this, I completely agree. And again, it depends on what the protected interest is. Because the way in which I understood the question, it was going towards the protection of the data itself or the information itself, which we see quite a few examples in cybercrime conventions and deal specifically with certain manipulations of data. But if we think about human rights law, at least the way in which I look at this, it's more about certain interests which can be impacted through information operations. Think about the right to life and different operations, the different information operations that can lead to harm to life. For example, if you decide not to undertake certain treatment because of this information, etc. You might also think in this way in relation to non-intervention, when what you're actually protecting is an interest of the state. So depending on the rule, you would either focus on the data point itself, or you're going to focus on another interest which can be impacted through the deployment of such information operations. Was I too soft-spoken? Is this why I have two mics pointing at me?
I'm going to pass this one down to you as well.
This one works.
So I think it looks like some of the batteries are dying. The one just died on this one. So to the extent that we can take that one.
I think this one's
off
working.
Yeah.
The ones that maybe just pass it around, that might be the best way to.
We have two operations.
Okay.
No, three with that. So I
Three
think
with
it's
this. All right,
going
let's
on
see if
with
this
it.
works. Okay, thank you. That was a great question. Others before we move on? All right, so if we're saying here that information, large category, but the harm, and I'll use Tsvetelina's word, the harm from the information creates that subset that is most significant, at least for our panel. Then let me start with you, Emily. What is the obligation then of, for example, the government when they see information or come across information that they think will lead to harm? What's the obligation of the government? And Gavin, I'm coming to you next with what's the obligation of the private sector?
So clarifying, I'm gonna hit you with a question back. When you say come across information, is this just information the government sees and is collecting, or they're thinking about redistributing, or just that it's out there and we have an obligation to?
For right now, let's just say it's out there. We'll get to the next question.
Okay. Harmful, that can also mean a lot of different things. So harmful how? Is it harmful to the way the public might see us as a government, like our own government? Is it harmful to how we may see partners and allies? Is it harmful to how they may see our adversaries? And we probably just want to kind of leave that out there, you know what I'm saying? So so I think it depends on what kind of harm and then to what degree intervention, one, is warranted, and two, whether we really have an authority. Really, we talked about the right to receive it ad nauseum, but you really can't get enough of it, right? Do people have this inherent constitutional right to receive it? And that right is not just constitutional right, it is encapsulated in human rights treaties as well. So I think that there are many layers to answer that question probably more thoroughly, but that would be my initial response.
Well, let's in an attempt to keep this at the international law level as
Yeah.
opposed to descending into domestic law. Let's say it's harm that would be it's information that would be harmful, violate a human right or some other piece of international law. Does the government have an obligation to do something with that information?
Under the ICCPR, and we talked about extraterritoriality, and the US's position on that. So if the US were to say, yes, it's within our borders, and probably there is some sort of obligation that attaches because we are a signatory and ratifying. But if it's something that we saw that perhaps would affect outside of the four corners of our territory, I'm not sure if, depending on which nation you ask, whether that obligation would attach. Now, if the majority of states are moving toward, as we've already discussed, that it does apply outside of our territory, then that obligation would likely attach in terms of notifying whether or not, and to what extent notification would be helpful to those who'd be affected by that harmful information. So, and that's a question I had when we talked about extraterritoriality, when we say in the cyber domain, how do we define that in the cyber domain, right? Is it where that information will be felt in the geographic physical world? And so in that case, if it's felt outside of the borders of a particular nation, then we are worried about extraterritorial influence. But if it's felt still inside your own nation, then of course the aspects of the ICCPR and other relevant human rights treaties would apply. So that is a question I didn't have a chance to ask, and I think it's relevant. And we talk about extraterritorial application in cyberspace of human rights. How do we define what extraterritorial is? And is it an effects-based approach like we approach so many other things in the cyber domain?
Yeah, and we had some discussion, I guess, on the last panel, at least mentioned by our Irish colleague about due diligence and various states' views on due diligence. That might also play into this. But Gavin, what about what about a major tech company, a Facebook, a Google? What obligations, if any, do they have when they see harm coming out?
So there's both obviously legal obligations in some parts of the world, and it can differ, but there's also the ethical and the business obligations. If you want to be a platform that people use and trust, you're going to try to keep your platform clean. And it's interesting, the strategies that companies have to take in order to try to achieve that end, because, for example, the US government is largely hamstrung by the First Amendment. The US government doesn't submit takedown requests to platforms in the US because they see something on there that they dislike. There are other countries around the world that expect that you will take down any shred of anything that could be defamation against somebody in their government, and they'll actually bring criminal cases against people for defamation. So there are some times where big American corporations and some other corporations overseas will refuse to comply with takedown requests or demands for data, if it's a defamation case, for example, or where they'll take action that the US government could never ask for to take down misinformation or disinformation. What's incredibly hard is when you think about, I think we often abstract the concept of disinformation, misinformation, malinformation from the facts, the reality. And when you think of it at the practical level and the job of actually trying to keep disinformation off a platform, it is insanely difficult, especially when you think about the scale at which this happens. You're talking about platforms that could have over 1 billion people using them. And you're trying to impose a single set of rules over how people are supposed to behave on that platform when they're coming from countless different cultures, backgrounds, different ways of life, different expectations, and then trying to hire enough people to monitor what's happening. So people have this vision in their head that, well, you know, you build AI as a classifier, boom, 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 it's all taken care of. Absolutely cannot work that way. There's a concept of recall and precision that applies whenever you try to roll out something that's going to operate at scale. The better the recall, the more bad stuff you'll capture, but the lower the precision, which means you're going to capture a lot of stuff that's not actually bad. It'll make mistakes. The better the precision, the lower the recall, which means you're going to miss things that are bad. And there's just no effective way technically to get around that problem. So the challenge is often we see, for example, in the EU right now, there are laws that are pretty strict on requiring companies to identify and take down harmful information. Well, first of all, as I think the gentleman in the front row said before, some person's misinformation is another person's truth. A lot of these things are very, very subjective, and they're very much opinion. So I think Facebook was pretty creative or clever when they came up with the real person requirement. So you couldn't post, you know, have a fake persona and post on that platform because it was almost impossible to control things at the truth, not truth level. There's just too much distinction, too much uncertainty, and misinformation, even the definition there. What if it's misinformation that the person believes is for the public good? That wouldn't fall under that definition. So
Well, malinformation is true information just used for nefarious purposes.
I think most misinformation and disinformation is malinformation. Even after, if you look at what the IRA put out, if you ever sat down and went through the things that were published by the IRA, it's difficult to say most of those aren't true. It's usually opinion. It's, you know, for example, I remember one that was a picture of American soldiers in a combat zone and then Russian doctors wearing, you know, medical gear. And it said, American response to an international crisis, Russian response to an international crisis. I mean, is that true or not true? It's an opinion. The real pictures, there were real people. It was in a context where those statements weren't false, but it was intended to mislead and to
make a point.
To make a point, right? So now, if the individual posting that, so let's say it's Vladimir Putin and he's got an account on the platform, and he's completely clear about who he is and what he's saying, then it's opinion, and you've got to worry about the right to receive, the right, you know, that it becomes very, very, very difficult very fast. So the hard thing, I think, is seeing a lot of divergent laws, and we're struggling with this in the US right now with the debate around Section 230 and how much protection that gives platforms.
Well, I don't want to descend into the US law, but just tell us what Section 230 is since you brought it up.
It basically is a law that says that the platform that publishes information is not responsible for the content, that the person that put the content there is responsible. So there's a lot of debate going on around this in the United States.
And the debate is making the platform actually responsible.
Right. So it's a struggle, but as we have divergent laws that are going to start requiring in different places, different rules, it becomes very hard. I think where we have kind of missed the boat on a lot of this is the effort should be on requiring a certain ethics by design component in how technology is built, all potentially disruptive technology. There should be a model that we expect companies to follow like we do for cybersecurity. We can point to standards that it's not the government that comes in and does those things, but they can be audited and they can be checked to make sure that you're doing the right things to do your best to try to limit the harm.
All right, well, I'm going to come back to both of you about what then the interaction should be between the government and the private sector. But let me first go to Ori and to Tsvetelina. Any comments on either of those, but also what role, if any, does civil society or other aspects of society have in this identification of this malinformation?
This one was not working. Is it working?
No, it goes.
Right. The first one is on mapping out all the relevant legal frameworks for us to combat these harms. And I think that to understand the way in which one can effectively combat these harms, one should think about not only state responsibility and the obligations of states, but also the obligations of individuals, either under international criminal law or under domestic frameworks, and similarly the obligations that entities might have under domestic law. And I would like to talk a little bit about this relationship between positive and negative obligations of states, because I think that's quite critical when we talk about information operations. When we talk about the negative obligations of states, let's imagine the indoctrination practices by Russian ministries in occupied Ukrainian territories. For many of these, the question of extraterritorial jurisdiction would not apply because actually there is spatial control over these territories. So we should not assume that when it comes to negative interstate questions, it is going to be necessarily one that will cause difficulties on extraterritorial application of human rights law. But for positive obligations of states to protect those under their jurisdiction, I think that here comes a very critical point of what exactly can we require of states to do to protect us against these kinds of harms. And one of these requirements would be to regulate domestic corporations, but also to regulate the behavior of individuals in those countries. So I think that here we go into a discussion of the practical measures that can be taken, linking back to the discussion from yesterday. What are the kinds of things that work? Because there hasn't been all that much attention to how our minds are protected under international law. There is a lot of focus on the physicality of things. But I think that now with all these discussions also in the Jus ad bellum, in IHL, we start to grapple a lot more with how we need to be protected on the side of our mental health, our thought processes, and the outcome of these thought processes.
I'll just slightly add to that, I mean, looking at it from a purely international law perspective, I would basically say that, well, civil society actors don't really have obligations. I mean, there may be obligations on the state to prevent certain acts of civil society actors or to preserve their rights and so forth. But from a purely legal perspective, it is very difficult to say they have obligations. Perhaps individuals have very specific obligations in the specific context of international criminal law, but that's basically as far as it really goes.
So let me just pose a question for you then. In an application of due diligence, let's assume a robust principle of due diligence in international law with respect to this. Assuming, right, I'm certainly not saying there is. If civil society put a state on notice of a mistis mal event, would that be sufficient for the state to have the obligation to respond?
So I think it would certainly, because there's often a debate, is knowledge required for a due diligence obligation to arise? So if I know that in the Corfu Channel case, for example, the classic case of due diligence, the question was whether Albania had knowledge or could not have not had knowledge, or however it goes, that there was a mine in its territorial sea. So in that respect, it could bring into play international legal obligations, which is why the distinction between objects of international law and subjects of international law is quite useful here, because they may not be subject to any obligations, but at the same time, their acts can certainly bring into play various obligations of the state.
Yeah, agreed. Tsvetelina, do you want to add to that? You're shaking your head in agreement.
No, I'm not shaking, I'm nodding very vigorously.
Yeah, that's what I mean.
Yeah.
Okay, good. All right, before we come back to Gavin and Emily on the interaction between the government and business, any issues or comments from any of you out there on this? Yes, please. Yes.
I'm curious about the extrajudicial application. In regards to the decision of the European Court of Human Rights in 2023 and wider if this was the case of UK survey of mass surveillance abroad, the court says you collect the data inside your country, you process the data inside your country, the data is in your control, therefore it triggers the application of the European Convention. So I'd be curious how you perceive that judgment of the extrajudicial application, or at least what US positions are as it relates to data that we control process here. And then my only other question is about causation with a lot of the things that Tsvetelina started talking about. the right to life with some of these information operations? Like, I'd be curious to understand how we prove causality with a lot of the potential conflicts.
Yeah, maybe we'll start with the second question first, and then we'll come back then.
There is no one test for causation in international law, and there is no one specified test for causation in human rights law. It's also a question of whether we even need to have a test of causation for certain of these rights. It might be that there is a question of foreseeability of certain types of harms. And then there is a question of how direct in the chain should the foreseeable harm be. So I don't think that there is one way to answer this question, but the foresight of a certain harm, whether it's in respect to the right to life or when it comes to privacy, I think would be sufficient to trigger the obligations of the state.
Before I go to Emily on your question, I want to know what you think the answer to your question is.
On causation?
No, on the extraterritoriality
I
question.
have long defended the argument that if you collect the data and store it, you trigger
You own
human
it.
rights obligations. And that the entire analysis that we wasted so much time on with surveillance, extraterritorial application, Marco writes articles on that, completely useless. When all the data is stored at home, processed at home, of course you should have human rights obligations. Because you chose to engage in a mass surveillance program in that way. Now, why shouldn't you be bound by human rights obligations? But obviously that's not necessarily what the US position.
So from a US domestic law perspective, it hinges less on location and more content and target of the intelligence mission, right? So who is the target of the intelligence collection? And then even if the target is a foreign entity, are you incidentally collecting US person information? So from a US perspective, that is the trigger. It's not necessarily the geographical location. It's what is the content of that collection and who is the target of that collection. And if you are targeting a US person as defined by our policy, or you're incidentally collecting US person information, then you have heightened requirements, hoops you have to jump through in order to keep and retain that information. So I think it also goes back to the US, long held position that we've already talked about. And I've already mentioned that our human rights obligations don't extend beyond the US, right? US borders. And so it's a moot point. So we're just going to get rid of that. We're going to flick that bugger, if you will. And then we're just going to focus on the content and the target of that. And I think that is sort of how our domestic apparatus is set up from a policy. But I will say that with the emergence of data, especially commercially available information, we are facing new legislation proposals that one passed in the House, the Fourth Amendment's Not for Sale Act, right? And again, I don't want to get too much into domestic law, but we are facing new challenges, if you will, to answer to.
Just one quick follow-up.
Yeah.
I see that changing with the executive order on the privacy framework with the European Union, where we allow the Europeans to have access to our courts. Are we not saying essentially that they have certain privacy rights that are being impacted by foreign surveillance? Is that
Are you going to two finger on that?
Yeah, and I was gonna mention that. Stop. That's in the whole never-ending category. Is that a policy requirement or a legal requirement? I think we would take the position that it's a policy choice to do that in order to have the agreement with the European Union and try and continue cross-border data flows. Alex Joel left here shortly. He runs our Privacy Across Borders program, and he's intimately knowledgeable about that. But I think the basic structure of our Section 702 collection program is the target.
Section 702 is it's basically a program that allows.
It allows the collection of intelligence, of communications of foreign persons overseas, not within the United States, but the collection point is in the United States because of the general infrastructure of the internet. And so it's the incidental collection of US persons information is separate.
Yeah.
And with respect to the foreign person, I think we would still say that our ICCPR obligations are not triggered because that's an overseas person and just having the data wouldn't do that. Right. So the other piece of it now, the additional layers of protection we've put on are matters of policy.
I'll just remind you that Gary also is not speaking on behalf of the US government, though I have heard many US government people say the same thing. So, okay, anything else before we come back?
And there I bud in and to be the annoying positivist. And Asaf and I have had these conversations for a long time. But I would say, look, the European Convention of Human Rights is very clear in its text, the ordinary meaning of the text in its context is that we are concerned with persons who are subject to the jurisdiction, not with information. So however much it perhaps should be, and I do recollect you saying the word should be the law, at the end of the day, I just find it very difficult to reconcile with the customary rules of treaty interpretation of the ECHR. And that's the ECHR, I would say probably a very similar analysis would apply to the ICCPR.
Okay, all right. Anything else? Yes, please.
That's right. And this is to Gavin, and sorry if I misunderstood this. Did you say the US didn't have takedown requests for platforms in the US? I might have just misunderstood that. And then one kind of actual question. If we're talking about like responsibility and knowledge, civil society makes reports all of the time about harms like around the world, in the Philippines, in Myanmar, in Brazil, to platforms that would even just that are violations of human rights law or even might facilitate violations of human rights law. So just wondering what you see as like companies' responsibility and what actions they should be taking when they do receive these very credible reports by civil society. Often civil society comments that, the platforms don't do enough. So just wondering.
Yeah, so just to clarify, you would not be talking about the due diligence obligation. That's with states. You'd be talking about a terms of use problem or something.
Yeah, like the
that.
escalation platform.
Okay, yeah.
Escalation.
All right, go ahead.
Yeah, so on the second question, and I think this comes back to, every company is going to have a different approach to doing this. Some are better than others, obviously. And it's difficult if a company is merely relying on, what public opinion will say. These are things that get detailed to a level where if they're not in the press, somebody might not know about it. That might not put sufficient pressure on the company to take the action that you would think ethically the company should take. That's one reason why I think that, building ethics into the product development is so important. Having an advocate within the company at a high level who is arguing for the ethical outcome in every situation.
So before you go to the first question, let me just ask you, would Facebook have viewed civil society's input as a good thing? Oh, thanks
Yes.
for letting us know.
Yes, no, Facebook is, my experience here, it's been a while, it's been a few years since I was there, but we would take those things very seriously, but it would be difficult because of sometimes, for example, US law. So ECPA requires certain kinds of legal process to share information, even to preserve information. So sometimes you would almost be, have to look for somebody in the US or law enforcement or somewhere that was interested in the same problem.
Okay.
That could make a request so that you could preserve things. And I think that's true for a lot of providers. It's the unintended application of law in the context of how businesses operate and the decisions they make is a bigger problem than you might realize looking at it from the outside. And the second question was, what was the first question?
The first question was when you get a request, a takedown, right?
Oh,
Takedown
yeah.
request.
So the US generally, in my experience, I don't think I ever once saw an example where, mostly I engaged with the FBI and with other federal agencies. We would regularly get takedown demands, legal demands from other countries. You didn't see that in the US, and certainly not from the FBI. They might alert us to content that was on the platform with the expectation that, you have terms of service and do what you think is appropriate with those terms of service. But they wouldn't do it with the expectation that we would take any particular action.
All right, your follow-up
point.
Go ahead.
So I'm looking at Meta's latest transparency report. There were 73,000 total requests by the US, 88%, which were 88% of requests, which some data was produced. So that's just from the transparency report, and that might not necessarily be a takedown request.
They're not,
Might be an
those are
information.
production
Yeah.
requests. Those are subpoenas, search warrants, court orders.
Okay. And then the last thing is, as someone who dedicates a lot of hours of my life and is part of coalitions that dedicate a lot of the hours of their life from civil society around the world, we're trying to get the platforms to do more to kind of take down, or to at least like look at content and look at violations of law around the world. And it's something I would definitely like to have proactive engagement on, but it's just, it's tough out there.
Yeah, good on you. Good on you. Let's go to Yuval, and then we'll come back to the panel on the question I have. So go ahead, Yuval.
Yeah, I'm not sure whether this is, I might have missed the train. It could have been the previous round, but on the definitional issue, I'm a bit I want to maybe propose to those who have taken the position that it's not so important whether it's misinformation, disinformation, malinformation, or truthful information, because each of them could be harmful to certain people in certain contexts, that maybe the first three are in a separate category because their very propagation does generate societal harms in the sense that it does erode trust in information, and it does create an inability to distinguish between truth and false, which is adversely affect the so-called proverbial market of ideas and democratic institutions to function. And I'm wondering whether this distinction in itself has normative value under international law, whether this could in and of itself justify that governments or maybe businesses as well under a business and human rights framework would take certain measures. This doesn't necessarily apply takedowns, but it does mean that this is something that is of concern and needs to be somehow addressed. So I was a bit tomatoes kind of approach. I thought maybe we could revisit this.
Yeah, well, so, and I mean, trust was a issue on an earlier panel, right? And the key that makes, if anybody want to add anything about that particular thing before I come back to these two?
Yeah, sure. I think that the suggestion in the previous round was that there is no automaticity to the consequences of how we consider these categories under specific rules of international law, unless this is something which is inbuilt as an element of the rule. This is not to say that they have no normative purpose, because as you say, these can have specific harms that they entail, which might be different between truthful information and incorrect, false information. So in that sense, I completely agree with you. But again, it's a question of what are the types of harms rather than just having automatic classification, truthful, non-truthful, and therefore violation or no violation. Again, unless there is something in the specific rule that requires that automaticity. There have been academics such as Stephen Wheatley who have spoken about questions of non-intervention and coercion and the fact that here it matters whether it's false information or truthful information. Others would say that doesn't matter. It's about the manipulation that you're causing. So in that sense, there's an ongoing discussion. There is a normative value, but I would say we shouldn't assume this automaticity of implications just on that basis.
That's well said. All right, Gavin, back to you. Let's assume that you have some stuff and you want to interact with the government somehow. What's the mechanism by which you do that?
So it's a very sensitive process. And first, I would say there's been a lot of discussion lately too around whether or not the government should have any communications with social media platforms and other similar platforms. I think it's critical. I think it's absolutely critical. I think it should be very clear that there should be.
Yeah, so just to be clear, there was a Supreme Court case on this in U.S. domestic law, not international necessarily, but in U.S. domestic law. That's been a real robust discussion of late in the United States, and the determination was that the government can have this interaction, right? So now keep going, sorry.
Yeah. And I think there also should be much clearer rules internationally with when corporations, businesses can talk to each other and share information with each other, because that internal sharing among corporations can be extraordinarily valuable. Most companies, I would say most, are afraid of doing it because there are so many different laws and rules that they're constantly afraid of stepping over a line accidentally. So some of the bigger companies are lucky because they can hire people like former federal prosecutors that really know where the lines are and have lots of international experience. It can help them make the right decision and do it appropriately, and engage with the government very carefully. So what generally, I would say in the industry, the best practices is to, if you had information that showed a threat to the public, human safety, that sort of thing, you're going to do outreach. You're going to communicate some portion of that to the government, to a government that can react. What you produce or how you do it is going to depend very much on who it's going to. Why? Because again, application of law. If something goes to the FBI, basically they just need enough to understand the problem, to open a case, and to issue their own legal process. And the rest of it they can do on their own. If you do the same thing with a foreign government, you might only create frustration because they'll see the problem, but under US law, in order for them to get any of the data that would really be actionable evidence, they might have to go through the MLAT process. It would take months to try to get somebody in the US to issue a search warrant. So it really depends on the circumstances, but you have to think carefully through what are the consequences of each step.
So in the last couple of years, we've had a couple of very clear examples where governments have shut down the internet in areas to diffuse potential rebellions, potential revolutions, potential revolts, potential just dissatisfaction, right? I mean, is that if you saw something like that coming and you believe that this was going to lead to death, injury, destruction, et cetera, would a civilian company feel compelled to notify the government that this was on its way?
I think, well, that's a deep question. So first of all, for that to be something that only the platform sees instead of a government and its intelligence
Well,
services.
assume at least you don't know if the government's seen it yet or not, but you now see it on your platform.
And you're saying it with respect to that particular government or another
Yeah, with
government?
that particular.
I mean, I think anytime that, my personal view is when any provider of services to the public sees a threat to human life and there's a way to protect that life, they should take action.
That's an ethical
That's
issue
ethics.
for you, not, you're not basing that on a human rights.
I'm basing it purely on ethics, but there is an exception under ECPA that allows that. There are exceptions under US law that allow that.
All right, and Emily,
And I mentioned
oh, go
US
ahead.
law because US law is applicable in most of those circumstances.
So Emily, I know I'm asking you to step way out of your role as a government employee, but just if taking the government as a whole, would you anticipate that you should expect this kind of information from platform providers or from corporations?
I think the trend is the relationship between private sector and the government, whether it's US government or other governments, is only going to become more important and more intertwined. So if that, I think in my personal opinion, that is the direction we're going. And if that's so, then this sort of obligation, however we're going to phrase it, probably needs to be more in the forefront of these private companies' minds, because whether that's in peacetime, I mean, the unique thing about the cyber domain, I know everyone in this room knows this, right? But it's completely man-made. And it's almost entirely owned by the private sector. I mean, those are two factors that just are not true for any of the other domains. And so we exist in this space because it exists because of private companies. And we're so reliant on them and their cooperation to help us ensure the safety and protection of our citizens. What's more, looking forward in conflict, private companies' involvement in combat, in current combat that's going on, current ongoing hostilities, I mean, that's only going to become more prevalent as well. And so we need to be thinking about that aspect as well. So yes, I think just from a stepping way back and looking forward to the future, 100%, we need to start thinking about these tough questions, because they're only going to get tougher because our lives are going to only become more intertwined. It's a marriage we cannot get out of. I mean, it is a forever kind of thing. And I don't see it getting any less so.
Yeah.
Can I make a shameless plug too?
Please do.
So I'm on the advisory board of the Marcula Center, which is the ethics center at Santa Clara University in California. And we've come out with a handbook on the ethical design of disruptive technology. And the whole concept behind that is to think ahead and to bake in product development, the things you will need to keep people safe, the things you will need to protect society, which also includes, it might mean manpower. You might need people, more people than you thought, in order to develop and launch a product. It's not all about just getting it out the door. The company should be thinking about what would be how could this be used badly, and what will we need to try to mitigate that harm, which might mean you better get funding for that in the early aspects of the development. So it is, we, as a society, we live in a very challenging society when it comes for business development. People are in a hurry to get stuff out, to be first to market. There are some times where that results in, harm. And that to me is a bigger problem than how to control it after it's already out there. Like trying to develop things in a way that prevents the harm in the outset.
Yeah. We've talked a little bit earlier in this panel about the incitement, right? The ICCPR incitement provision, and maybe it's worth thinking about, are there should we broaden that domestic obligation And Ori, maybe I'll come to you with that question in just a second. We've got some more hands, Gary.
I'm just wondering, trying to put myself in the shoes of a general counsel, one of these companies. There's no doubt that public-private collaboration is becoming more and more prevalent and necessary. I think about the ethics approach, which it certainly on the surface makes sense, but then you get clashes between, from both the government side and the business side. At what point now am I creating government agents in these companies?
Mm.
This was the Missouri Biden case, which actually didn't say it's okay. The Supreme Court punted,
Yeah.
right, on a standing basis. So that's still floating out there. And from an international law perspective, you have the attribution question, right? At what point is the collaboration of companies becoming something that is attributable to the state? How much control is the state exercising over those activities that might rebound, against them? It's just fraught. It's really challenging.
But it's manageable. We know what creates agency.
This is the podcast. Watch
You
it.
read my
Have it.
mind. I was like, this is-
Ready to go.
We know what creates agency. We know if you are careful in how you work through this process and you document what you're doing as you do it, and you have a record of when you made a decision and why. And that will mean that almost certainly there will be times where you say no, where the government wants something or is putting pressure, and the company has got to have the willingness to stand up and say, no, we're going to fight you on this.
Well, the last argument of the podcast is we can say that, but the Fifth Circuit came down very differently about what actions should the platforms became the agents of the government for in terms of taking down content. So
I would
it's
say
challenging.
the Fifth Circuit case, one of my biggest problems with that is it conflated
Agreed, but
the executive branch, politicians, White House with law enforcement. And those are two very different things in the way they behave.
Sir, to you.
If I could go back to your point about ethical obligation to warn about human life. But the companies, the platforms could be in between two different nation states. Are you going to provide Russia warning when Ukraine is about to do a counteroffensive? And then are you going to provide Ukraine warning when Russia is about to attack? You're going to be caught in the middle.
And that was one reason why, I was a little bit trying to get a little bit more detail. And look, this is my personal opinion. I can't speak on behalf of any of these companies because even the one I used to work for, I don't work for anymore. It's very hard. Those questions come up a lot. There are countries, if you look at that transparency report, there are countries, and go to others, there are many countries that US companies have never disclosed information to in response to legal process. What's the ethical thing to do if they see a potential threat against life in one of those countries? Or, child exploitation. Those are really, really hard issues. And I have my personal opinions about how they should be addressed, but it's certainly not easy.
All right, I know I've encouraged participation. There's still some hands up, but I'm going to move on, Jim. I will get you the next time, I promise. So Tsvetelina, I want to come to you in just a second on this issue of interfering in thought processes. But first, let's go to Ori on that question I asked. What other things are out there, Ori, that we might expand, this idea of inciting to? What other things would you say ought to be included?
So I think actually the issue of incitement itself, I don't have many suggestions as to what should or should not be included. I think that's more of a politician. And I do not like to delve into policy considerations, but I do think incitement, the issue of incitement itself is actually quite interesting at the moment, because I think it might be giving us a glimpse into how certain rules of international law are at least attempting to enforce certain rules of international law relating to cyber operations. There's currently 2 parallel cases pending before the International Court of Justice between Armenia and Azerbaijan. The broader context, of course, is the Azerbaijan-Armenia and Nagorno-Karabakh conflict. And these cases are classic examples of what Sir Christopher Greenwood coined Cinderella jurisdiction, trying to squeeze a massive dispute into a very narrow compromissory clause. And what's interesting actually in the Azerbaijan application is that one of their submissions is that Armenia has violated the International Convention on the Elimination of All Forms of Racial Discrimination, either by itself disseminating incitement to racial discrimination or against Azerbaijanis, or by not preventing incitement to racial discrimination by its nationals, presumably in its territory, against Azerbaijanis. And this is very likely, if we're going to see these kinds of interstate disputes relating to cyber activities before international courts and tribunals, I think this is kind of the avenue we're going to probably be seeing that, seeing these disputes squeezed into compromissory clauses under very specific conventions. So here we have the CERD, the Racial Discrimination Convention. We've heard earlier the Genocide Convention. I'm not going to comment on that one. And also other various conventions relating to the prevention of terrorism, whether it's terrorist financing, and even beyond that, organized crime, and so on and so forth. So I think that's really where we might be heading in the interstate domain. We've heard about the human rights domain earlier, so I don't think there's too much to add to that. And perhaps also even to a certain extent, investor-state arbitration, because there are foreign investors in the territories of other states which have assets of various forms, often digital assets, which could be targeted by whether local or even transboundary actors. And that could potentially, although I would argue probably usually otherwise, implicate certain protections under those bilateral investment treaties or multilateral investment treaties, such as the obligation of the host state to provide full protection and security to investors on their territory. Would you like to add to that, or?
Sure.
So add to that and then go to the issue of interference with human rights, if you would, Tsvetelina.
First, let me for the point, which is that one of the consequences of taking a wider view of the landscape of applicable and relevant rules when it comes to the impacts of information operations is that this allows us to also think of the so what question. What are the procedural mechanisms that these different rules might give us to ensure some degree of implementation of these international protections? So there's a few things that I would like to say here. The first one relates to this idea of harm and harm to thought processes. And linking to Yuval's question from before, I think it's really important for us to keep our mind on what exactly it is that these information operations are doing and are posing. For the past year, I've been working as a legal advisor at the Reckoning Project, which is an organization combining journalists and lawyers for accountability in relation to Russia's aggression in Ukraine. And what we focus on is the indoctrination of Ukrainian children in occupied territories. So, for example, there we see this connection between certain types of completely offline indoctrination practices with online indoctrination practices, where, of course, you can imagine the regular textbook of having the portraits of Putin and the flags on the walls. You're going to have the change in the textbooks that are being provided in the school curriculum. But this is accompanied by a number of information operations whereby on social media you have children heroes turn into symbols of the Russian fight against the villains of Ukraine, if you like. There were hacks even of baby TV showing Russian propaganda on it. And we can see with those types of harms that it's not just about the change in the opinion that is being sought, but the change in the very process of thinking of these children, whereby it would be much more easy for them to ingest information uncritically. It is also going to create or exploit existing or create new cognitive biases in the way in which they deal with information. And this leads us to another question, which is, well, if we have this broader understanding of the harms, what are some of the relevant legal rules? And I think it's a good moment for us to start thinking about the forgotten ones and the sharp-end issues. And one of them is the right to freedom of thought, which is a fundamental right, which is absolute, non-derogable in the ICCPR, but at the same time, there is very little specification of what exactly it protects. Now, we know that there's some threshold questions of what exactly is covered within the meaning of thought and what kind of protection it engenders. it's quite clear that, for example, we are protected by not having punishment for our real or inferred thoughts. But how are we protected from manipulation under that right? And here, some relevant questions might be the vulnerability of the person. We see in the case with indoctrination that really shows how you're using this idea of a child who might be very impressionable and might be digesting this information much more uncritically. You have the question of the power disbalance, the fact that very often they're away from their parents. So you're really creating and increasing these areas of vulnerability. And sometimes it is these cyber discussions that are actually bringing to the fore existing uncertainties in the law. That's actually very common in IHL, in the jus ad bellum. Now we're starting to rethink our notions of force, of violence, because we see certain things that happen in relation to cyberspace. And then the final point is that if we start expanding our idea of the landscape of rules that are relevant, this might lead us to some interesting ways of thinking about procedural mechanisms. Or we already spoke about some of these under the Convention on the Elimination of Racial Discrimination, for example. Freedom of thought is protected. And here we also have a dispute settlement clause that would allow recourse to the International Court of Justice to the parties of this convention, subject to negotiation. We can also think of different conventions that have different procedural mechanisms, branching out to individual criminal responsibility for such informations. But countering this type of harm requires a lot of thinking across regimes and a lot of thinking of what can we actually do to give some relief to those who are suffering, and not just identifying rules in the abstract, which is a big chunk of what we have to do.
So that was an excellent segue from the first part of our discussion to the second, because that's exactly, I think, some of the kinds of information that a nation might want to target, to take down, to get rid of, to remove, right? I just want to say a couple things before we dive in on this targeting issue. There is a LOAC panel tomorrow. We are going to try and stay away from the LOAC issues of targeting. So again, I keep doing air quotes around targeting. I'm not talking about targeting under the LOAC. I'm talking about targeting more broadly. I want to point out that there is, in case it doesn't get mentioned tomorrow, there's an excellent post by Mike Schmidt on targeting under IHL on the Liber Society's Articles of War blog. If you don't go to that blog often, you ought to. It's the best blog in the world at the moment. And Mike Schmidt's got a really good article on this issue right there. You know that Mike Schmidt, for those of you who know him, there's been an ongoing kind of gun battle about this idea of, is data an object in the context of IHL? That's one of the issues that was brought up in Talon 2. Since Lise is here, I thought that I know that I want to know the answer. I thought we might just ask Lise what the status of Talon 3.0 is. Lise.
That was smooth.
You didn't know you were going to be a panel member, did you?
Maybe rather than like focus on the status, maybe I should just briefly say what we're trying to achieve with Talon 3. And in broad terms, we're doing two things. We're, of course, updating Talon Manual 2.0. We're updating it in light of the national statements that have been produced. We're updating the legal analysis in light of all the scholarship that has been produced since its publication. And then the second thing that we're doing is we're somewhat expanding it. We're adding some new chapters. We've produced a pretty robust new chapter on individual criminal responsibility, for example. Lindsay Freeman was one of our experts there. We were working on a very 70-page draft of human rights in cyber. So we're significantly expanding the human rights chapter, adding something on international trade law, investment law. So those are the two things that we're doing. Updating, expanding Talon 2, updating in terms of state practice, updating in terms of scholarship, and then expanding where we felt that we either did not go into sufficient depth in Talon 2 or adding entirely new areas.
Okay, thank you for that update. We appreciate that. So with respect to targeting, I want to take a little bit of a twist on this just initially. I'm sure you've all read the statement, data is the new oil, right? And so that seems to indicate that there might be data in and of itself that might be targetable. There might be reasons to target that data. Gary Korn's written a great chapter on a book that talks about sabotage and how you might go use sabotage to get to this data. I just want to open this up to the panel.
Eric, co-author.
I just want to get to this panel. What do you think about this idea? When are the circumstances when you would think about targeting data or information? Again, not in the LOAC sense, but in the non-LOAC sense. When would you do it? Emily, let's start with you.
I think I like to start with the basic assertion that we are so intimately tied to our data. I mean, I forget my wallet at home, it's whatever, right? I forget my phone, I'm turning the car around, and I think we all probably can relate to that. And just as simple.
Can I just interrupt you? Say, I ask my students this all the time. Would you rather lose your car or all of your information? And they all would rather lose their car. They don't care about their car compared to their information.
It's an emotional, right? It's an emotional response. And I use this very simple example with my students, right? If someone were to burn down my house, I would feel this profound sense of loss of everything inside of it, the memories, photos, artifacts, things of that nature. If someone, I have 20,000 photos on my phone and half of them are of my children. And if someone were to just wipe that entire thing, including any backup, all my Instagram feeds, I mean, I would argue that most of us would feel that same human response, right? And so when we talk about data and how important it's only going to become more important and more sensitive, especially when we talk pattern of life information, the fact that we have our phones with us all the time. And so when we talk, critical cyber infrastructure now on the state level, we've talked on the human level, but states are made of humans, right? And so what we value, that's going to feed what we value in terms of critical infrastructure. So when is it appropriate? I may not have the answer to that question, but I do think that when we talk about targeting either in and outside of LOAC, there's going to have to be significant considerations when we are touching some critical infrastructure pieces and the second and third order effects of that and whether or not the juice is really worth the squeeze. Because I think critical infrastructure, rather asking whether data is an object, I argue that that's not really the right question. Or the question is, how are the effects being felt? And that's not a new proposition, but of course, are those effects being felt in the critical infrastructure space? And does that require a heightened level of legal scrutiny when we're deciding whether or not to launch that particular operation?
Okay, Gavin, I'm going to come back to you. So let me go to Ori on this. What would you do, Ori?
In terms of
what things are targetable? What things would you say would be targetable?
I think, well, look, going back to my experience as a legal advisor, I mean, you'd be surprised of what comes across your desk. And I'm not going to tell you what came across your desk.
Oh man, you give us that lead in and then it's come on.
I mean, we could still be subject to criminal prosecution in that respect. But it can really be anything because you just never know. And that's why I think at the end of the day, whenever we speak of data, it's all one big category, even if from a functional perspective, we give it various different categories. And why ultimately, as you mentioned, we don't look at it. It's less interesting, at least for me, usually, but what's the actual operation from a technical perspective, but more what's that operation doing, particularly in the physical real world. And then asking myself, well, does that violate international law, or is that just something which I would tell someone off to do it?
Okay, Tsvetelina.
Just based on this discussion, two things come to mind. The first one is that there seems to be a distinction between data and value of data as such, which Emily is bringing to the table, which then, of course, the first bell that rings is the question of right to privacy.
Yeah.
But there is a second one, which is access to data as a precondition for the delivery of certain services. And I'm thinking, for example, in the healthcare context, where you would need to not have access to data so that you would be able to deliver necessary emergency service to patients, etc. And depending on how we think of this, there will be different rules of international law that would be relevant. I know that you don't want to go into the LOAC context, but of course there will be questions around the meaning of attack. When it comes to the USAT vellum, what do we understand by force? A number of human rights obligations are going to be relevant. There might be even questions around Dr. Abir before mentioned self-determination. So there are many different rules that will be relevant to this, but I think there is a question of how do we think of data as something which is protected as such, or something whose protection is based on the needs that we have for certain service capability.
How should we think about it? And both would be equally targetable and protectable?
Anything and for any purpose. The only question is which of those purposes and types of acts would fall within the rules of international rules, such as the control and notification.
Okay, so I'm going to go to Gavin next and ask him as his perception if he's the person who's being targeted, the civilian corporation. But first, any of you want to weigh in on this issue of targetability of data? Gary?
Eric, we touched on this in the chapter that we co-authored. And I wonder if.
Did you
know,
just bring that up to raise that
the
issue?
panelists, I think there's an interesting phenomenon out there where the questionable position about data as an object under the very specific lex specialis analysis in LOAC has started to bleed over into the ad bellum or other areas of international law and state responsibility where it really has no place. And I think that's the point that's been raised. It's
Like the military objective analysis, that kind of stuff?
yeah, well, that as well, but certainly you can get into that debate in IHL or LOAC about, right, the very specific treaty interpretation of object as tangible and so on. But outside, the issue there is whether or not you're triggering a certain level of legal regime protection or not. Outside of that, it's generally focused on consequence. So what is the consequence you're achieving by messing with the confidentiality, availability, integrity of certain data? But I've seen some of this bleed over effect of that conversation into, because, well, we make this sort of correlation between IHL, right, use in bello and use ad bellum. It's all a part of the big mix. And so it's, you see this bleed over effect. I don't know if anybody, if you've seen the same sort of thing.
I will just say one of the conclusions we come to in that article is that if, let's just say there was a state that had data that they were using as training data to build an AI tool that would eclipse your national capabilities, we conclude that it would not, that you could not act in preemptive self-defense at that point to attack the data in order to poison the data to prevent the AI tool from being effectively created, right? I mean, that's our conclusion. But I think as you get closer and closer to the development of that AI tool that would then eclipse your country's capabilities, you might get closer and closer to an argument where self-defense might be a justification for that kind of action. So any comments on either of the?
I think the whole bleeding over is actually a across the board issue when it comes to identifying international law applicable to cyber operations. So for example, scale and effects, that's 100% an issue of armed attack, but then somehow it becomes a test for use of force.
At least in the cyber context, right?
Yeah, well, yeah. Well, I would say it isn't, but that's a different issue. But yeah, I think certainly we see perhaps it's kind of a symptom of specialization in the field. So people who specialize in cyber operations almost solely focus on cyber operations. But we see this in other areas of international law where you kind of build silos. So you have trade law silos who look at WTO from a very specific WTO perspective. Some would say they're also human rights law silos, and so on and so forth. But I think certainly it's a problem, and these rules are different rules which are subject to different tests. So when it comes to use of force, using tests for use of force, tests for defining attack under IHL, and then using that for attack for use of force, they're actually two very separate concepts. So for example, in a kinetic environment, an invasion without shooting a single bullet is still a use of force, most likely an act of aggression or and after attack. But from an IHL perspective, that act in and of itself probably doesn't implicate or might bring into account, might create a situation of belligerent occupation, but doesn't actually implicate any rules relating to attack, at least. So I think it's a symptom of a broader problem here, which is probably a symptom of an even broader problem with international law more generally and fragmentation.
All right, Gavin.
I am not one of the Army Corps. I have no idea what LOAC is.
That didn't pass genetically somehow. So let's assume that that some company, some large tech company that you might hypothetically work for in the future or in the past is now the object of a targeting action by a state. How do you perceive that? What do you do?
So targeting as in.
They want
coming
your,
to get your data,
they want
coming
your
to
data.
destroy your data?
Either one.
Yeah,
Take,
I mean, obviously, this
destroy.
would be rather upsetting.
All right, and that concludes our
Be
panel.
most effective. And
And then what would you do?
I mean, honestly, so if we identified something like that, obviously you're gonna go to the government for help, right? What would we do? We'd go to Mandiant, we'd do everything we could if it's the same way if it were an attack from a non-governmental source. And in reality, initially, we probably wouldn't even know. It'd probably look like just any other hack to start. So what?
But when you discovered it was a state involved, you would treat it just as every other hack? You wouldn't do anything different?
Think the only options you have are to treat it the way you would anything else. You try to stop it, you try to kick them out of the network, you need to shut things down. All the obligations to disclose to regulators are going to exist. You're going to have to notify customers, you're going to have to notify regulators and governments, and you would be crazy if, as a company, you didn't reach out immediately to the FBI or whoever your local law enforcement authority is to start looking for help.
Okay, thank you. We've only got 4 minutes left. I want to save some time for the lightning round, but is there one burning question that we haven't gotten to? I'm looking at you, Jim. No? All right. Last word. We'll start with Tsvetelina and move this way. Last word on anything we've talked about. What is it you haven't had a chance to say that you wanted to say?
I'll actually pick up on what Ori said just before, which is on the need for us to be not really within that silo of cyber, but have a generalist hat on. And the reason for this is that very often the way in which we specify certain obligations in relation to cyber will have ripple effects much more broadly. So for example, the way in which we specify the definition of the prohibition of the use of force in Article 3.4 of the Charter will have implications for countermeasures because of the boundaries that come of lawful countermeasures that can't implicate the prohibition of proper use of force. So in that sense, within all of these discussions, it's always good to be mindful of the specific cyber effects that can be had with these information operations that we've been discussing. But at the same time, we have to always have in mind what are the broader consequences of what we say. And especially within that area that I was discussing with freedom of thought, that's a very important line to draw. What is the line between lawful persuasion that we actually want to have and something that we would consider prohibited? So in that sense, just a note of caution for how we set ourselves.
Thank you. Ori.
I don't really have too much to add, but I'll have to just echo, that the generalist perspective is something which is really of the essence, and I can't remember exactly who it was, but the generalist is an endangered species in international, and I think we need it back. We need to preserve the generalism as much as possible when it comes to these types of discussions, since I think a much more holistic perspective, whether it's treaty interpretation or state responsibility, identification, customary international law, all these different things need to be considered from a generalist perspective if we're going to actually have accurate legal analyses. And I think it's kind of ties back to the first panel of today, when we're discussing issues of sovereignty. We need to, as people who specialize in the cyber area, we need to be able to have discussions with the generalists or the lawyers who deal with issues of law of territory when we're speaking about sovereignty. And if we're speaking about, on the what cyber lawyers are speaking about inherently governmental functions, whereas the people who specialize in law of territory are speaking about the exclusivity, or speaking of Island of Palmas exclusivity of exercising the functions of a state in its territory, then I think we have a problem here.
Thank you. Gavin?
So I think the only thing I would say, there's, an audience here of people that work on very significant international law issues, and thinking about some of the challenges of the inconsistencies in international law when it comes to some of the issues we've talked to today. If you have the opportunity in your various roles to have an influence on that, I think that would be very helpful. Thinking about what could, I think most corporations, certainly publicly traded ones, they want to do the right thing. Their lawyers want to do the right thing. The people who work there want to do the right thing. There's a lot of uncertainty because of inconsistencies in law, which prohibits or at least prevents some of these companies from making decisions that they could make. And I'll give an example. So when the US government passed CISA, the Cyber Information Security Act, it had a carve out from some of the other laws that prevent sharing of information with the government or with other companies for cyber threat indicators. When that happened, first of all, I don't think there was a big uptick in the sharing of cyber threat indicators. And I think there was a downward sharing of other stuff, because what the lawyers and companies started to look at is like, oh, there's a carve out here, but there's not a carve out for this thing, terrorism, or this thing, you know, whatever it is, fraud. And so it actually inhibits. It had kind of a negative overall effect, I think, unfortunately. That's my perception from talking with lawyers and other companies. So we got to be very careful in the way we think about how laws will actually be applied, and think about like, okay, that's great here, but as part of this, we need to go across the border and talk to our neighbors, because if they don't do something similar, it's pointless in an international community where almost every service is used by people around the world.
Thank you.
I'll be brief because I've learned one thing as an instructor: once you're over, your students just stop listening. So I exactly what Gavin said. Who else wants to do the right thing? Like the warfighter wants to do the right thing. The commanders I've worked for, that's the majority of my time as a judge advocate, is advising commanders at the 06 1-star level and below. They want to do the right thing, but the only way that they can do the right thing is if the great minds in this room come together, as you're doing now, to create clear guidance, right, that they can follow, that they won't need me necessarily to interpret things. So I just reiterate everything that's been said, especially what Gavin said, is like, keep doing what all of you are doing. It's been so fascinating just being a fly on the wall here, hearing all of you speak. And I really look forward to the continuing development. So I can teach it and my successors can teach it in our classroom, because again, I can only teach the law and policy that exists. And beyond that, I can ask the tough questions to get their wheels turning, but I can't give them a lot of answers a lot of times. So thank you so much for everything. And thank you for this opportunity.
All right, please join me in thanking the panel.